I'm Evan Law. I am okay. Maybe there was a pause. I'd like to welcome everyone to the webinar with Manifest Law tonight. I'm Evan Law. I used to work for the USCIS Administrative Appeals Office, and so I'm happy to be here and answer any questions you have. And so we'll turn it over to you to let us know your questions. Okay, so the first question, what do you expect for the January visa bulletin? When will the gold card become effective and how will it affect pending NIW applications? Will the priority date move faster? Okay, good questions. About priority dates, we publish a lot of things on our website, so we'll give you some links to go to for those details. About the gold card, so the date that the form was to be released about that was December 18th, I believe. And we don't know a lot of details about how that program will work, exactly how it will align with the framework that has been established by Congress. So to be continued on that, I would suggest you follow our content, and we'll be providing updates on these things as they come out, and as well with the priority dates. I would recommend you look at the links that we've published about that. Okay, next question. What will be a good time to go for first-time H-1B stamping next year, given all the uncertainties? H-1B renewal in September 2026, H-1B approved in 2023, and renewal in September 2026. Okay, so this is a challenging one to answer because last week the State Department issued a directive about new vetting that will go on, and so we're not sure exactly how that will play out, but we are seeing um, examples of people's appointments being canceled and rescheduled, um, likely because of this additional vetting. So there are a lot of uncertainties happening right now. So what I would suggest is just stay in close contact with your attorney and you know try to communicate all of these dates and hopefully you can come to a good conclusion. I would say a lot of anytime these changes come out, I would say wait for the dust to settle a little bit after that. So perhaps you can be looking at this in February or so, but that's what I would suggest at this point. Okay. Do applicants for EB-1A need to provide any certain number of recommendation letters? What would be the minimum number of letters needed? So when I adjudicated cases, I approved cases that had 3 or 4 letters of recommendation. So there's really not a set number. Each of these cases is very unique, and so there's really not a definite number that you need to have. We usually recommend people provide 10 letters, but usually from those 10, we pick the ones that are the strongest to submit. Um, it also depends on the criteria that you are requesting. A lot of the letters of support go towards showing a leading or critical role, but others can touch upon things like um, the original contributions that you've engaged in, that you have developed. It just really depends on the things that they will be writing about. So um, I would say at least aim for a minimum of 4 to 5, but it really depends on uh, how you're going about the case and the factors that you're trying to meet. Okay, so next question for EB-1A applicants, what is the realistic chance of approval given increased scrutiny and rising applicant numbers? What can an applicant and legal team do to increase the likelihood of approval? Okay, this is challenging to answer because, like I said, every case is different. While there is this increased scrutiny going on, every officer still has their own understanding of the framework and how to adjudicate a case. So, um, some of the things that you can do to increase the likelihood of approval. Well, one of the things I would suggest is make sure that there aren't aspects of the support letters that demonstrate that one person has written all of the letters, or that AI has drafted a lot of what you're providing. There's this authenticity that officers want to see in the documentation provided. And so um, one of the things that I advise my clients is that in a way we're playing a game of chess with the officers in that what I recommend is that you focus on the criteria that you meet the strongest and don't give them any reason to issue a request for evidence um, or deny the case for those reasons, and then discuss the other matters that maybe you feel are not as strong, but in the totality still um, demonstrate that you've risen to the top of your field. You can discuss those issues in the final merits analysis. So this is probably something that we could talk about for, I don't know, a very long time. But I would just recommend that you ensure that um, you are meeting all the regulatory requirements that you need to, as well as the details that are in the USCIS policy manual. Okay, next question. If someone has a priority date in late 2026 for EB-1A, when can they expect to file I-45? So here, what I recommend is you go to the visa bulletin. It will give you the dates when you can file. What you need to make sure of is that there aren't any times that the visa bulletin uh, retrogresses. That's probably unlikely to happen, but the visa bulletin gives you those additional dates. We can provide some additional links for you as well. Okay, when does USCIS issue an RFE versus NOID? And can one come back from receiving a NOID, or is it better to abandon the application and start a new one? Okay, so oftentimes RFEs or NOIDs are issued to buy the officer additional time. They probably wouldn't like to admit that, but um, the other aspect of this is if there's any aspects of your evidence that is just not as strong, or if it leads the officers to, you know, question certain things, that can be a reason for an RFE or a NOID. Um, as far as coming back from annoyed, I don't ever recommend just just taking a blanket approach to abandon a case, like if annoyed is issued, because sometimes it might be that the officer was planning to issue an RFE and maybe their supervisor suggested, well, why don't you convert it to annoyed? It's hard to say. There were times that I adjudicated cases that when my supervisor wanted me to issue an RFE, I didn't feel the need to. We did anyway, and then the person withdrew the application. But we were planning to approve the case once these additional documents had come in. So it's a conversation to have with your attorney as to what is the best approach. If the NOID really references something that perhaps you didn't consider, or that you really see, wow, this is going to be very difficult to overcome, that might be a good time to abandon the application and start a new one. But it's really a case specific type thing. So I know that's it's hard to give generalities without seeing the actual details of the NOID. But sometimes the officers, I think, ask for things that they really shouldn't. So, okay, the next question is USCIS I-140 processing times are degrading. Can you give some idea on how service center times and functioning have changed under the new SCOPS classification for all centers? Okay, so this is one of those things that leads me to just talk more generally about the fact that USCIS is a massive enterprise. And any times there are changes, uh, the goal ultimately is for them to find ways to be more efficient in certain ways. But um, there can also be growing pains with that. So what I'd say my concern is that there's kind of a lack of clarity at times. For example, sometimes I've logged in to see how a case is being processed, and it's just unclear where the case is. So I don't really have a great answer for you on this, other than hopefully if we can be patient with this, with some of these changes, that hopefully over time things will become uh, more efficient. They do have these stakeholder meetings where they receive input from attorneys and the public at large. So hopefully over time that these things do uh, become more efficient. But I remember at the AAO, there were times that I saw an appeal that I could make a decision on very quickly, and I realized it'd been sitting on a shelf for 2 years. So I don't think things like that are happening as often, but yeah, those, in other words, we just have to wait and see. Hopefully, this things become more efficient over time. Okay, if a case has received an RFE in denial twice, and was told it was because of an officer with very low approval ratings, what is the probability of being assigned a similar officer in refile? Okay, this is also one of those kind of $1 million questions. A lot relies upon the luck of the draw, with you know officers that are very strict in some ways. Um, it's hard to say. With a lot of this, you also have to look at, there's training that's going on behind the scenes. So it may be that you had an officer that was recently trained on an issue, and so I think it's just hard to say how much of turnover is happening with the USCIS. These are just things that are very difficult um, to uh, to understand. But my philosophy is basically look at the framework of immigration law and do everything that you can to present your case so that even the most strict officer could approve the case. And I think if you go with that mindset, um, then that puts you in a better position for success. Okay, next question. Okay, the NIW I-140 petition rejection rates are extremely high. Further to this, the processing times are increasingly manifold. So is it futile to file for NIW I-140 until 2028? I don't think so. And the reasons for this is, we get a lot of questions asking about why denial rates have gone up, um, and what's the cause of all of this. um, but I never suggest that anyone should just say it's futile to go forward. What I would suggest is that you really look at the framework, and have a really in-depth discussion with your attorney about what are the strengths of your case, what are the weaknesses, what are the ways that in which you could make your weaknesses stronger, as far as whether that's with your proposed endeavor or the aspect of you showing that you're well positioned to carry out the endeavor. Um, in essence, um, you need to really think through this as though you were the officer. Would this be a case that you would approve? What concerns would you have if you saw this? And then, I would suggest even reviewing a lot of things from the policy manual or AAO decisions and get some insights that way. But I never really come to the conclusion that it's just futile to go forward with it. It's kind of like in sports. oftentimes you can see, uh, you know, teams look at other teams that they've got to face, and but they're on their schedule, and so they need to just move forward and prepare the best that they can. So that's what I encourage you to do, is just put your best foot forward. Get the case as prepared as you can. If your attorney then suggests that maybe there are ways that you could make it stronger, then that's when I would say maybe you might want to wait a little longer. Okay, is USCIS likely to change the number of criteria that needs to be satisfied for EB-1A visa in the near future, or any other change expected in the final merits test? Um, we have heard some rumors of this, and it's hard to know if that is something that is likely to happen. This is one of those things that when I worked for the government, I really enjoyed being in the kind of the um, just that communication pipeline to understand what changes are on the horizon, and what we can expect. And now being in private practice, it's hard to just not know any of the cards that they're holding. So I don't know. I think it is likely that they might increase the number of criteria that needs to be established. When you look at, I'll try to make this concise in a way, but when you look at Kazarian and the framework that it laid out for EB-1s, kind of the underlying rationale underneath that was that someone could meet 3 out of the 10 criteria and still not really be at the level that Congress envisioned, or that Congress stipulated, which says someone has risen to the very top of their field with sustained national or international acclaim. And so with the Kazarian framework, we have the two-part test now is you have to meet 3 out of the 10 requirements, and then show that the quality of that evidence meets the general purpose, or uh, kind of the general goal of the statutory language. So, as far as your question about, whether things could be changed in the final merits test, in some ways, if more criteria were required, but they modified the regulations in a way that just says you just need to meet 5 of these criteria, and we won't do a final merits analysis. In some ways, that could be a positive, because people would know a little bit more what to expect, rather than you go through the first part of the test, then get to the second part, and you just hope that the officer sees that you meet this in the final merits. So we'll just have to see. The I'm uh, I don't know. I can see positives in both ways. On the other hand, by having to meet more of the criteria, that also could lead officers to just engage in more scrutiny on certain aspects of those as well. So it could be difficult either way, but there also might be some silver linings there. We'll just have to wait and see. Okay, for EB-1A or O1s, what would be considered a high salary for an electronics engineer in the Bay Area based upon your past experience or interactions? Is 150,000 eligible? Okay, so good questions. With things like this, really the best thing to do would be to pull up the actual documentation from the Bureau of Labor Statistics. Oftentimes I go to ONET Online, which references the BLS. Um, Perhaps. I would have to bring up the specific details of this. Generally, as an adjudicator, you kind of just get a threshold of where you start to expect high salaries to start, and that's in the threshold of it. There are times I just remember looking at cases and saying, okay, someone here's at 100,000. It just it um I don't know. I'm sure every officer views this a little differently, but in my view, you kind of get to that 140, 150, 160,000, you start having the conversation about high salary, but depending on the occupation, obviously. But then in my view, also when I see 200, 250 or more, those are just more impressive. Really, the ultimate thing with this is showing the documentation, but you also have to recognize that these officers have limited amount of time, adjudicating your case, and so the overarching goal is for you to impress your impress the officer. And so anyway, that was a long-winded way to say we need to look at the documentation, but it looks like that is um, you know, getting in um, the the framework you need to be. Okay, can reference letters from early stage startup CEOs stating volunteer contribution to raise funds and get projects be used to meet O1 or EB-1A awards criteria? Startup is not the employer and has no earnings yet. Okay, so the awards criterion is difficult. You have to show that it's a lesser nationally or internationally recognized award. So what um, you know, what we're talking about here is, I mean, the letter showing or discussing the volunteering contribution to raise funds, that's not something that's going to meet the fact that an award needs to be given. So, um, is this still something that can be discussed in the final merits? Um, Yes, it really depends on the overarching type of case that we're talking about. So um, my initial thought is that this is something that could be used in the final merits, but I don't really see this being something you'd want to rely on it in the criteria stage. Okay, could you clarify if there are any specific regulatory criteria where you would like additional evidence or clearer documentation? Um, so this is, um, yeah, I mean, this brings up a lot of things in my mind. I'll talk about some of the usual ones that officers see in EB-1As that um, where usually one part of the evidence isn't provided, for example, leading or critical role. The other part of that is that you have to show the organization that you um, are with in providing that leading or critical role. You have to show that has a distinguished reputation. And so sometimes evidence of that is not provided with scholarly articles or published material. Sometimes the emphasis is not as heavy on whether this is a professional publication or major media, and if so, we need to see comparable uh, statistics of the readership, this circulation details, that type of a thing. Um, with the membership, oftentimes it's difficult for people to obtain the bylaws of the organization to demonstrate what are the requirements for admission to have that membership, as well as documentation showing who was it that adjudicated your membership. They have to be nationally or internationally recognized experts. So that one can be a very difficult one. The membership one is a criterion that oftentimes I will move that to discuss in the final merits as long as we have other criteria to meet. So those are some of the main ones I would focus on, or I would point out. Okay, is there any part of the final merits analysis where you think additional context from my industry would be helpful? Um, yes, so the overarching theme, so are these three things. These are kind of phrases that are in the regulations and the statute. You have to show that you've risen to the very top of your field, that you have sustained national or international acclaim, and that your achievements have been recognized in the field. And so if you are in an industry that perhaps is one that there just isn't a lot of recognition that takes place, it would be helpful to have some more context about your industry that you can shed some light on that. Perhaps there are ways in which internally you may be recognized or nominated for certain things that demonstrate that you've risen to the top of your field, but you quite don't have that external recognition that you need. I guess in general, what I would say is that there's a lot of times when I've seen cases where the evidence showing someone has risen to the very top of their field is much higher than the acclaim aspects or the recognition. And then I've seen other cases where the acclaim is higher, for example, with researchers or who have a lot of citations and things. That outward facing type of thing adds more acclaim, and then but maybe it's just not as strong as showing they've risen to the top of their field. So yes, what I would suggest is any context you can provide in the industry is helpful, because we are trying to compare you against others in the field, and we want to know as much as we can and understand what your field entails and how you fit in the niche that you have within that field. Hopefully that makes sense. Okay, next question. Because auto renewal will no longer take place for H4 EAD, how can I ensure that renewed EAD can be obtained in time? My H1B has to be renewed at the same time the H4 EAD expires. Well, this is a challenge for sure, and in many ways, we're at the mercy of hoping that USCIS is as efficient as they can be to approve these. The auto renewal was put in place because of backlogs, and so now that this has been taken off, as I mentioned earlier, there are these stakeholder meetings where USCIS does get feedback on these type of things, and so hopefully the efficiencies are there to make sure that you get the EAD in time. But if not, you need to find a way to have your voice be heard, so that and that others as well who are having these issues can bring these things to light. So at stakeholder meetings, they can understand that perhaps they need to go back to allowing for the EAD auto renewal. Okay. Try manifest. Could you clarify if there are any specific regulatory criteria where you would like additional evidence or clearer documentation? We had a similar question. Perhaps I'm not understanding the question right. If there are specific regulatory criteria where you'd like additional evidence. I mean, I think what I was trying to point out before was that there are certain criteria where often evidence isn't provided. But whether there's anything to add to that with additional evidence or clearer documentation. Sometimes the letters in support about critical role don't really provide enough details about what it is that that the applicant has accomplished, or what they did, whether what they did really was impactful for the company. And just stating that they had an enormous impact is not enough. We really need some details about why it was aligned with the objectives of the company, and how it demonstrates that what the person performed really advanced that. So there are quite a number of details in the USCIS policy manual about these types of things. So what I would recommend is just that attorneys and applicants look at those examples and those details to see if there are ways that you can ensure that you have provided sufficient evidence on this. So okay, for EB-1A, does judging at university hackathon and first robotic events count towards judging criteria for EB-1A? Yes. So the thing with the judging criterion is that it's one of the kind of lower hanging fruit in a way that it is one of the easier criteria to meet. But what I recommend people pay attention to is that when you get to the final merits analysis, the officer is going to be looking at each of the criteria that you're trying to meet, and they're going to address that and say, okay, now we've seen this evidence, now I'm going to discuss it in terms of, does this show that you've risen to the very top of your field? And so one of the things that I ask potential clients or clients at times is I say, okay, so when you talk to your colleagues and you tell them about this judging experience that you've had, how do they respond? How impressive is this to other people? How impressive is this to you? And really what you want to be doing is trying to present the things that you are most proud of, that are most impressive to you. And so um the other thing I would say about this is that the the ways the officers should be viewing these things is that they look at your experiences in the totality. But unfortunately, with the time spent on these cases, sometimes what happens is the officers, instead of looking at the complete picture, because generally people have stronger criteria and evidence in one area over another, or and then maybe they have a weaker part. But still, that weaker part of the case still helps establish the required criteria that you need. So anyway, the in my view, the way this should be um, analyzed is that a person says, okay, in the totality, I see this is who you are as, and these certain things demonstrate that you're an expert in your field. But what happens is instead, the officers take a kind of compartmentalized view and they say, okay, let's look at your awards. Do your awards show that you've risen to the top of your field? Does judging show that you've risen to the top of your field? Does it show sustained acclaim, right? And this person could have presented at conferences and things, but they're not really focused on that. And so, really, if you see that they're doing that piecemeal approach, even in a request for evidence, I think it's helpful to remind them, look, you need to review this in the totality. But so those are just some thoughts on that. Okay, when you get an RFE on originality and significance, but you haven't got independent reviewers apart from the previous one, can you focus on your findings, protocols, and citations? Yes. So one thing I'll say about the original contributions, one is just this one's very difficult to meet. So um, depending on the other criteria that you're trying to meet, if you meet enough of them, it may be a good idea to consider just addressing the original contributions in the final merits. As far as whether you don't have independent reviewers, um, but do you want to focus on the findings, protocols, and citations? Yes, I mean, those are definitely ways to establish the significance of what you have done. Scholarly articles, scholarly contributions are part of the this criterion as well. So citations, the findings, the protocols. What USCIS is trying to hone in on is how impactful have your contributions been, and I do feel like they go a little bit too far on this, and that they want to see that it's had a wide impact on the field at large. Sometimes I remind officers that it says significance in the field, but still the general perception is they want to see how influential you have been overall. So it's a very challenging one to meet. I don't think it's a matter of weakness to say, okay. I mean, you don't have to say, I see where you're coming from, but maybe you say, given that we've established these other criteria, I would like you to consider these original contributions in the final merits as they establish and demonstrate that I've risen to the very top of the field and the acclaim that I've received. And you point out the citations and these other protocols. Okay, next question. Okay, how long before one can see any movement on the 100,000 fee case from the courts? Asking so as to understand he or she should plan to travel to the home country. H-1B renewal is in September 2026. Okay, so it's very difficult to determine how long cases in litigation are going to play out. Um, So what what happens at times with litigation is that the attorneys for the government decide, listen, we're pulling back from this. Maybe we don't want to fight this as much as we thought. Or at other times they go all in and say, no, we're fighting this till the end and going all in that way. So it's very difficult to understand which of these um, s- you know sides of the line they'll be on. I would be inclined to think that this administration will be trying to fight this um, just all along the way with the courts. So um, yeah, good question. What I would say is keep monitoring things and check in with your attorneys around February or March and see, what they're seeing. You can even go online and just even look at what's on the docket of these cases and kind of get a sense of how they're moving forward. Okay, with the research papers published by others on my device that I invented, can I count these on the EB-1A criteria? Which one? So, hmm, um, it's a good question. So I think with this one, I would need more details, just um, because I don't know enough about the device you've invented. Um, anytime that someone has an invention that goes towards the original contribution. So I'll just say this generally. So when you have a patent for something, the way USCIS discusses this is they say, well, a patent shows that you have an original idea, but then they want to see how widely has it been implemented into the field. And so my question with this would be, well, um, you know, how widely has this been implemented? And so potentially could use this for the original contributions criterion, but it's kind of a nuance in a difficult criterion to meet. And so what I would suggest is just talking through this with an attorney and try to find what's the best place to discuss this. And it might be that it's in the final merits. Um, yeah, my apologies. Um, those are my thoughts on that. Okay, if my company receives awards, okay, that's the same question. Okay, is it necessary to specify every document on the petition as a way to show off the prongs or proven, or can you want to explain and use the documents attached? Um, Good question. So in some ways, I think people can actually hurt their case by trying to meet more criteria than they should try for. So, um, but the other aspect of this that's challenging is just the voluminous nature of these case types. Um, so there, you know, this is really going at the presentation of this. In some ways, I mean, Congress laid this out that these need to be met by showing extensive documentation, but at the same time, if you are kind of burying the officer in a lot of documentation that really is not as impactful as some of the others, you don't want them to land on the things that are just not as strong. And so what I would suggest is focus on the things that are the strongest in your petition. Make sure you have good citations to those and that you're highlighting the key aspects of those so that it stands out to the officers. I also recommend people highlight the exhibits so that those things are um, jumping off the page to the officer as well. So um, yeah, I think in general, um, And it's just a kind of a presentation preference. There are times when I prefer to do an exhibit where I say, okay, see exhibit F that has, these types of things that are all kind of lumped together, and we just kind of leave it that way, and I don't describe what exactly each of the pieces of the puzzle are. But generally I view that as the officer is just going to see the totality of it as they flip through it. Whereas some other things we really wanted, particularly for the strongest pieces of evidence, you really want to point that out what it is, and really draw their attention to it. Okay, so what is the minimum percent of profile readiness below which you don't accept cases for EB-1A filing? So with this, for sure, we want to be looking at, does some, does someone have a good likelihood of meeting at least 3 of the 10 requirements? That's the initial threshold we look at. So, for example, if I have a consultation with someone who is right, meeting one of the criteria and close to meeting 2 of the others, at that point, they're not ready to move forward with this. So usually it's that someone is really close to getting that third criteria, and depending on how close they are to that, we would make the call whether we would accept that or help them in that kind of profile building as they move forward. And sometimes it can be that people have really strong evidence that will be discussed in the final merits that kind of moves us forward, and even though we know they've got a little bit more they need to do on that third criterion. So it's kind of a case by case basis, but the main thing is make sure that you meet at least 3 of the requirements. Okay, next question. It's about adjustment of status under EB-1A. If you continue working without employment authorization after filing I-45 under EB-1A, the INA section 245K and 180-day does not exceed, what happens? Well, this is challenging because you need to make sure for the I-45 purposes that you don't have unauthorized employment. I'll just make a comparison briefly to, say, for example, if someone is married to a U.S. citizen, um, that forgives the fact that someone might have worked without authorization, but at the moment that the green card application is filed, they should not be working without authorization from that time on. So there's kind of these nuances to immigration law that basically the best way to go about things like this is just make sure you are not working without having uh, employment authorization. So, eh, what I would suggest is having a consultation with an attorney if these scenarios play out. Okay, if someone already filed EB-1A derivative visa and the case is in the consulate, but there's a backlog, can the person file an I-130 for the derivative outside of the US once the person has their green card? Um, so let me make sure I'm just understanding this correctly. Um, So, I mean, basically, yeah, anyone can have a family-based and an employment-based petition at the same time. Um, it oftentimes that happens because of backlogs that occur. So, but this last part kind of threw me. So once the person has the green card, it sounds like this is someone with a green card. Um, Okay, so let me see if I get this right. So the EB-1A So we're saying the person got their green card from the EB-1A and is then filing the petition for the derivative? Is that, I don't know, maybe I think I might need some more details on this one, but um yeah, I would suggest we just need a little bit more details on that. But basically, you can have a family-based and an employment-based petition at the same time. But if the person holding a green card is petitioning for their child, there's still going to be a backlog in that. So I imagine that they would be able to come over earlier as a derivative to the EB-1A. Hopefully, I understood that right. So, but feel free to reach out to us if you have more questions on that. Okay, does the EB-1A high salary criteria consider the total compensation or just the base salary? Yes, it includes the total compensation. And so, really good, well, oftentimes W-2s will include a lot of other aspects of total compensation. So that can be a really good way to show this just with the W-2, mostly because it's simpler that way. But yes, other aspects of the compensation are factored in. Okay, next question. Okay, can I enter the United States with the EB-1 or EB-2 program or not? Yes, so once those petitions are approved, you can. The difference is depending on what country you're from, there might be a longer wait time in the backlog. So I would recommend you reach out to an attorney to discuss the timing of all of that, and you can look at the visa bulletin and see what um, the wait times are for those as well. Okay, next question. I sold my business. It's an IT consulting company via M&A to larger private equity firm. Does this qualify towards commercial success criteria, even though it's not in the field of art? So the commercial success criterion is only for the field of the arts. So what I would recommend is that you basically try to use that evidence as something um, bigger. So what I would suggest is, I mean, with this, you could look at the evidence you have about showing you have a, a leading or critical role for an organization that has a distinguished reputation. You point to the private equity firm and the merger and acquisition that took place, and whatever documentation you can provide to show the prominence of that, the publicity of it. To but it also can be something that you use in the final merits analysis as well. So, but generally speaking, the commercial success, I try to avoid even that phrase, the commercial success, just because it applies to the arts. It's similar with the display of one's work that also goes towards the arts. But that doesn't mean, like, if someone has designed an engine or something and it and it's on display somewhere, you can use that. But I prefer to use language like, that it's being showcased here, so that there's just not overlap in the regulatory requirements. So in other words, you can use it, but I wouldn't refer to it in terms of commercial success, and certainly not toward that criterion. Okay, next question. Okay, considering the slow movement of final action dates for India for EB-1A, what is the current timeline for someone to get their green card after an I-140 is approved, if the priority date is in November 2025? Okay, so a lot of these things, and with priority dates, I generally refer you to a lot of the publications that we've put out out on our website and our blogs and things. Mostly because I mean, this is kind of a cop out. My focus is really on this substantive aspects of preparing cases and filing them, and the timing changes. And at times, I'll even just bring up to people that, check the visa bulletin, but don't check it every week because it's almost like watching grass grow to some degree. So I want you to be hopeful and I want you to be checking these things often, but I also don't want my personal view is that I would recommend you just kind of move forward and keep checking on these things from time to time, and stay in contact with your attorneys as far as when you can apply. But anyway, those are just some of my personal viewpoints, and follow our social media things, and then that'll help you stay aligned with where the priority dates are and the timing of things. Okay, so how many Google Scholar citations or peer reviews are considered strong for EB-1As? This is a good question, and it's one that I hope officers are being trained well on because it varies from different fields. Someone who's in a researcher field can be expected to have a much larger citation record than others. So, whereas someone in the engineering field or similar fields, they just aren't they don't publish as much. So, um, what I can say is some of the best reports I've seen when I was an adjudicator are reports that reference a given field and put you in a percentile as to um, where you fall for based on your citation level and the number of articles you've published and things like that. So that can be helpful. It is difficult to obtain that documentation, but it's one of those things that different officers view it, in certain ways that I remember hearing officers say, "Well, I prefer to see this number of citations," and I just always thought that was not helpful because I preferred to basically have an open mind about what I'm seeing and the work that someone has done. So it is one of the challenging components of this case type in that you are showing that you've risen to the very top of your field as compared to others, and so that is a challenge that's inherent in this. But there's really not a set number for these, but I'd refer you to those other reports. One of them is called an insight report, INCITE. Okay, so the next one, if the research paper I worked and the part of it I worked on used in patent, which is in the final stages of review, how does that qualify for O1A or EB1A, or can it be used? Okay, so that's a very important piece of evidence that you want to be included. One of the challenging aspects of patents is that oftentimes the internal details regarding the patents are kept confidential. The company owns the patent generally. Um, and so even obtaining support letters about the work on the patent can be challenging. And perhaps the company doesn't really want to disclose the details of, for example, this was based on your research paper. So, it certainly can be used, and I would try to do everything that you can to try to use that. But I would just remind you that even having a patent still is an uphill battle to meet the original contributions criterion. And so, um, but the totality of this also goes towards showing that you've risen to the top of your field. You've done something very instrumental that has led to a patent. So there are times when documentation is submitted that patents have been filed, or they're in the early stages. in each of these, they're not slam dunk pieces of documentation that I wonder if sometimes people were banking on that. So unfortunately, just like I said earlier, the original contributions is just a difficult one to meet. And so I would just recommend that you discuss this in the final merits and everything that um, that goes along with that. Okay, next question. Okay, do I need to be employed to file an EB-1A? How many reference letters do I need? How sustained must my impact be before filing? Okay, so the EB-1A is a self-petition, so you don't need an employer to sponsor you. You do need to show that you're going to continue working in the field, though, and so you will need to provide evidence of that. As far as how many reference letters you need, there's really not a set number. I said earlier that I had approved cases that had 3 or 4 letters in them. It just really depends on how impactful the letters are and and really what aspects of your career they're focusing on. How sustained must your impact be before filing? When I worked for the AAO and I left in 2019, I'd worked there 7 years. I worked about a year and a half in the EB-1As. Um, at that time, we were really, I mean, the kind of understanding that we had was, you know, 10 years of a career was kind of this benchmark, and now USCIS has come out to say, look, even people early on in their career can show that they have sustained a claim. And so my general view I I look towards at least 3 years of a claim of recognition in the field. But there really isn't a set year or a set number of years where this needs to be sustained. So, going back to your first question about do you need to be employed to file it? Well, you don't have to provide documentation of, here's my employment contract, here's evidence that I am employed, but you do need to provide evidence that you're continuing to work in the field. So the best thing that you can do is to be working in your field and continuing to establish yourself as an expert in the field. Okay, next question. My EB-1A premium case was denied. I submitted 6 criteria, but only 2 were recognized. I appealed and plan to refile. Have you seen similar situations and what strategies work? Okay, one thing that I will say that I didn't have this understanding, or I've kind of evolved to have this understanding now that I've been reviewing the cases that other attorneys prepare as well, and just recognizing how much time it takes to review a case. Um, so officers generally only have a few hours where they're reviewing these case types, and the difference when I worked with the administrative appeals offices is we had a longer period of time to work on the cases. I'm not sure what the current administrative appeals office's requirements are and those type of details are. But my general sense on this is that, having going through the appeals office can be a positive thing because one, you get someone who's going to look at your case and your evidence with much more time than was given initially, as well as the fact that there are attorneys at the administrative appeals office who are reviewing the case. In an ideal world, all the officers at the USCIS would be attorneys and understand the whole realm of how agency law works and regulations and things. And there are very good trainings that are provided to these officers and all of that. But at the same time, I've seen this. There are instances in which errors are made because there's this kind of lack of training or understanding of certain things. So, what strategies work as far as, I mean, where you've met 2 of these. So you basically need to do 2 things. You need to make sure that you can succeed in demonstrating that you meet at least 3 criteria, but then you also need to make sure that on appeal, you're addressing the fact that, um, that in the final merits, you have risen to the top of your field and you have sustained a claim. So, if you plan to refile, the that can be challenging in terms of, while the appeal is pending. um, there's generally one A file, and so unless things have changed, there may be times that you refile, but that basically gets put in abeyance until the appeal is done. There's some complexities here that I just don't know what the current internal procedures are. Sometimes people decide to go directly to federal court, so I'm not sure if when you say you have appealed, if you're talking about going forward with an appeal to the federal court or the AAO, the Administrative Appeals Office. But what I would suggest is just discuss this with an attorney and see what they recommend. If you really have a lot of additional documentation to refile, then I would consider doing that. But my first sense is wait to see what comes from the appeal. And in the meantime, continue to build up your case to refile if necessary, if your appeal is not successful. Okay, next question. Okay, last question. How much does an RFE typically delay EB-1A processing? Okay, so if you file with the premium processing unit, they will issue a decision. They're required to issue a decision within 15 business days. And if they don't, they will refund the amount that you paid for premium processing. Or if they issue a request for evidence, what happens is, as soon as you respond to that RFE, another 15-day window starts. And so a lot of this will depend on, well, how much are they requesting? Because that would affect how long it takes you to respond to it. So, um, but I'll also say if this is under regular processing, chances are you've already waited a really long time, and so then if you get an RFE at that point, it really just depends on the officer's workload and how long that gets sitting on a shelf until they can come back to that case um, and provide the opinion. So under premium processing, you'll still have a good understanding of when that will be addressed within that 15 business day window. Okay, so anyway, those were my thoughts. Um, uh, I'm fine if you reach out to us if there are any things that you need further clarification about. You can schedule consultation with us at this site, manifestlaw.com/webinars. Okay, well, it's been nice to be able to answer some of these questions, and feel free to reach out if you have any other questions. All right, take care.